A mother is accused of killing her own child. That sentence alone makes people already decide the case in their head. But court does not run on shock. It runs on proof. And so the real question here isn't how could this happen? It's whether the prosecutors can actually prove the most serious charge in the law: premeditated murder. Because if they cannot prove premeditation, everything changes. Here's what's been publicly reported. In early October, Ashley Buzzard left Santa Barbara, California, with her young 9-year-old daughter. Authorities say they traveled through multiple states on to Nebraska before heading back west and passing through Utah. During this time, investigators allege that Buzzard took steps to avoid detection. These included wearing wigs with her daughter and altering the license plate on the rental vehicle. And the child was not reported missing by the mother. Instead, concern arose when she failed to appear for a homeschooling check-in. This prompted school officials to contact law enforcement. And on December 6, members of the public discovered human remains in a remote area of Wayne County, Utah. Authorities later confirmed the remains were the child, that she had died from multiple gunshot wounds to the head. Investigators say cartridge casings recovered near the body were forensically linked to spent ammunition found at Buzzard's home and to a live round located in the rental vehicle. The firearm, however, has never been recovered. Based on these allegations, prosecutors have charged Buzzard with first-degree premeditated murder, alleging planning, deliberation, and lying in wait. No trial has occurred. No evidence has been tested in court. These are allegations, not findings. From the state's perspective, this case is about intent. Prosecutors argue this was not spontaneous. They point to interstate travel, disguises, altered plates, and silence afterward. Taken together, they say these actions reflect planning, not panic. They also rely on forensic linkage, even without a recovered firearm. They argue the ammunition connects the defendant to the scene and supports a narrative of premeditated murder. In sum, the prosecution wants the jury to view the movement, the concealment, as a single deliberate story. The defense does not need to prove what happened. It only needs to show that the prosecution's explanation is not the only reasonable one. Suspicious behavior is not the same as intent. People under stress may flee, hide, or act irrationally for reasons unrelated to a murder. A central defense theory could be this: behavior that looks like planning may reflect fear, panic, or involvement in some other activity that the person does not want exposed, unrelated to killing a child. That theory does not have to be what actually took place. It only has to be plausible. And without the weapon, the defense can challenge what linked really means. Ammunition similarity does not prove who fired the shot, when it was fired, or who else may have had access. That uncertainty is where reasonable doubt lives. Now let's turn to the cross-examination. This is where the case tightens. Does concealment equal premeditation? Does silence necessarily equal guilt? Does movement across states equal intent? Or are we filling in gaps because the story is emotionally unbearable? If the state cannot show when intent formed or how the killing was carried out, then jurors are being asked to infer motive rather than see it. Now let's examine the law. First-degree premeditated murder requires proof of intentional, deliberate killing, not just a tragic outcome, not just suspicious behavior afterward. The intent must exist before the act, and the burden to prove never shifts to the defendant. Circumstantial evidence can meet that burden, but only when it excludes reasonable alternative. And now, my ruling from a legal standpoint and from years of practice in criminal defense. This is the case where emotion threatens to outrun the evidence. Yes, the allegations are truly disturbing. Yes, the travel, the wigs, the rental car, the ammunition raise serious questions. But as of now, we still do not know what actually happened at the moment the child was shot. We do not know who else may have been present. And we surely do not know whether the behavior labeled planning was tied to something else entirely. That doesn't make her innocent. It doesn't make the story finished. And in a system built on proof, not instinct, that matters. Because in the court of public opinion, yes, conclusions come fast. But in a court of law, they must come carefully. Thanks for watching. If you want real legal analysis without the fluff, please subscribe. And for deeper coverage of this case and hundreds more, visit crimesdigest.com. And always remember, the truth matters and so does reasonable doubt. See you in the next case.